Hi, it's Mike DelSignore, Massachusetts criminal defense attorney. Today's video, I want to talk about what happens if you're a non-citizen and you're charged with a criminal offense in Massachusetts. As everyone knows, President Trump in his second term is even more aggressive than in his first term, trying to deport people that are not citizens. So if you're here illegally, if you have a green card, criminal charge will put all of that at risk, and you should, one, never take a continuance without a finding, without talking to an immigration lawyer. Make sure you understand the consequences, because there's something called an aggravated felony. If you have an aggravated felony, and that's not even considered a felony under Massachusetts law. It could be a larceny charge. It's definitely a domestic, and then drug-related, gun-related, sexual crimes are all aggravated felonies. So most times, if an aggravated felony is a very serious offense in Massachusetts, but there are other crimes that potentially could be aggravated felonies that you might not realize. So an aggravated felony, an immigration lawyer is going to have very little ability to get any relief. Second type of crime that you need to worry about is a crime of moral turpitude under the immigration laws. So you want to avoid crimes that have immigration impact, and most of them do. And now the laws might be changing, so this stuff can change. If you're not a citizen, a quaff is a conviction for federal immigration purposes. You might hear or read online that a quaff is technically not a conviction. Well, that's fine for Massachusetts background checks, but it's not going to help you with the immigration authorities. They're going to treat a quaff as if you were guilty. So for many people, non-citizens, you want to take these cases to trial. In many cases, a judge is not going to give you a substantially harsher sentence if you go to trial. So keep your record clean. There are also what's called motions to vacate and reopen. This week in court, I had a case out of Chelsea District Court where I was able to undo a prior OUI offense. So a client who had 2 OUIs when he saw me now is 1, was still fighting the other one. So that's going to help him with immigration, because now he doesn't have 2 OUI offenses. Generally, a first OUI is not going to hurt you, but you should still take the case to trial because it will delay citizenship and things can change. So if you're not a citizen, you need a lawyer that can take a case to trial, because that's where your case is going to have to go. Sometimes it's going to be a hard case. Sometimes maybe they have a very strong case against you. Maybe it's only a small chance, but you might want to take that chance of being found not guilty. And the best chance you're going to have with a difficult case is somebody that's been doing this for a long time, passionate about trying cases in front of juries, that knows how to establish reasonable doubt and win difficult cases. And that's what I've been doing for 20 years, winning difficult cases. There's a lot of methods to how you win a tough case. Generally, I'll do a motion, some kind of motion. If it's a hard case, I want to hear some of the evidence beforehand. So I'll try to do a motion to suppress the stop, the seizure, statements. If there's a breath test, I'll try to get the breath test excluded from evidence if it's an OUI. So motions are a big part of winning a criminal charge. So if you're charged with a crime, whether it's domestic, an OUI, any kind of crime, I can help you. I'll go over the report, tell you what my strategy would be and how I'd approach the case. There are safe resolutions for non-citizens, but usually those are basically dismissals. So you want to avoid anything where you're actually admitting to the charge. So if there's any kind of colloquy where they're reading the report and asking if that's true, that's an admission. That's going to hurt you with the immigration authorities. So if you have a criminal charge pending, if you have an old case, especially if it's an OUI from 2011 to 2019, I can undo that case. So, and then if potentially if you have an old drug case, there might be some ways to reopen these cases to vacate prior admissions. So if you're charged with criminal offense, now's not the time to admit to the charge if you're not a citizen. The next 4 years is going to be very difficult. It's going to be a lot of changes, but the constant is you're going to need to win your case, avoid having a criminal record and criminal conviction, and I can help you with that. Call, text anytime, 781-686-5924. Mike DelSignore here to help you.